In Massachusetts, there are different types of custody. And when you typically think of it, you think of legal custody and physical custody. Now, legal custody is the right to make decisions over your child's welfare. So we're talking school, medical decisions, religion, those bigger legal issues. Within that, you have sole legal custody and joint legal custody. And it's exactly what it sounds like. Sole legal custody means that one person has the right to make those decisions. Joint legal custody means both parents need to talk together and come to an agreement on what to do to move forward. When we talk about physical custody, that is the placement of the children, where your kids are going to live. And that could be, with one parent primarily, and the other parent having a parenting schedule, or it could be more closer to a shared or 50-50 physical custody. And that can look like many different things. Now, the better you can work together, the more creative you can get with your parenting schedule. If you walk in front of a court, the judge is going to do whatever they feel is best. And it's usually not going to be what's best for you or your ex. So the best way to do it is to make sure that you're keeping that control within yourself and work together with your ex to be able to come up with a plan that works with how far away you live from each other, what your work schedules are, and what your children's schedules are. But those are typically the types of custody that we deal with. So if you're walking into court on a family law matter and you have children, you've probably heard the judge is going to decide on the best interest of the child. But what does that mean, right? Well, the best interest of the child is really, there's so much discretion for the court, but they're looking for what is best for this child based in these situations. The presumption in Massachusetts is that if both parents are capable, are healthy, are okay mentally, that there should be some sort of shared arrangement. However, if you start getting into domestic violence situations, if you start getting into any type of abuse of alcohol or substances, if you start getting into areas where the children may not be safe with one of the parents, that's where you'll see the court will often award one parent primary or one parent legal custody, and the other parent may have to show that they're actually safe for the children before they can have effectuated parenting time. If you've already been to court on custody, whether it's through a divorce or through a prior custody judgment, if you have that and it's set, then you can still modify that. Anything related to your children is always going to remain modifiable within the court. So in order to do that, you have to show what the magic word is, that there is a significant change in circumstances. Now, that may be that when you entered into your first order, your kids were too young. Maybe they were really small and being in one home was better for them. But as they grow up, as they get older, maybe a parent has moved closer. So it creates a situation where a 50-50 may be better for the children. If that's the case and you can show that change, then you can modify your parenting schedule. Once there is a custody arrangement in place, it is possible to move with your child out of the state of Massachusetts. However, that being said, you need to make sure that you talk with the other parent and you get their agreement in writing. If you are not able to do that, then you have to go to court and ask basically what we refer to as a relocation. And that means that you're asking for permission to take the children away from the other parent and into a different state. That can often modify the parenting schedule. Depending on the relationship of the children with the other parent, this may be possible. We have obtained relocations for parents to move, and more common because of the fact that New England is so small, we've been able to win cases where a parent is moving from Massachusetts to either Rhode Island or New Hampshire or somewhere right in that general vicinity. Another issue that comes up pretty frequently with moving is even within the state. So if let's say somebody's living in Western Mass and they want to move down the Cape, that's a significant distance that can actually interfere with the parenting schedule. So even though that's even within Massachusetts, that might be something where if the parent doesn't agree, you still have to go to court to even move that distance. So it can be done, and you need to make sure you do it correctly and either with the other parent's permission or the court's permission, because if you don't, the other parent has the right to go in on an emergency motion and ask for the child to be sent back, which could result in a change of custody. So don't do that. If you're dealing with a custody issue and you're looking for some guidance, whether you're initially getting started or maybe there was an order that you'd like to see changed, feel free to give us a call at O'Connor Family Law. We'll set you up with a free case evaluation and we'll walk you through your options and make sure that we're pointing you in the right direction so that you can get the result that you're looking for.